During the course of my client's medical malpractice case, she asked me how much I think her case is actually worth. After doing an analysis, I tell her that her case is worth $1 million. Now, as we approach trial, the defense makes an offer to settle her case for $500,000. Is she going to use what I told her previously a year earlier about the value of her case? Is she going to use that and throw it up in my face? Would you like to know the answer? Come join me for a walk near the canal as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The answer is most definitely yes. My client is going to say for the very first thing that comes out of her mouth is, wait a second, you told me a year ago that my case was worth $1 million. What do you mean that the defense is only offering $500,000? Half of what you told me my case was worth. And you know what? That is a fair statement. That's a fair question. Because if I told her that her case was worth $1 million, the fact that the defense has now offered only half of that, $500,000, now there's a problem. Now my client is upset. Now she's angry. Now she's frustrated. And she feels disrespected. Why? Because she believes that the defense should know exactly what the true value of her injuries are worth, and the fact that they offered half of what we believe her case is worth, now she feels disrespected and she believes that the defense is not operating in good faith. Is that all true? The answer is maybe yes, and then again, maybe no. So let me go back for a second. During the course of this lawsuit, my client suffered significant harm and injury as a result of a doctor's carelessness. We hired a number of medical experts to support our claim, to show that we are slightly more likely right than wrong than what we are claiming is true. During the course of the lawsuit, the defense attorney reached out to me knowing full well that they had a problem on liability, that they believed that their doctor likely was careless. And they wanted to see if we could try and begin negotiations during the course of the lawsuit. At that time, my client had not yet completed finishing her treatment with her doctors. We did not know for certain the full extent of her injuries, about whether or not her injuries would be permanent, lifelong, and disabling. We believed, at least my client believed, that they were. However, her doctors were not so sure. Her doctors were not sure whether she needed additional surgery, whether she needed ongoing medical care and treatment. But because the defense had reached out to see whether we were interested in trying to negotiate, it was critically important for me to go ahead and do a full evaluation and an analysis about the value of her injuries as it existed at that time. And I went ahead and made the assumption that these injuries were permanent, that they were lifelong and permanently disabling. At that time, I was able to come back to her and tell her that my research revealed that her injuries are worth $1 million for full value. So what does that mean? It means that during the course of discovery, if we were to try and settle this case, the defense most certainly would want to try and obtain some form of a discount because of the fact that we are now trying to settle this case sooner rather than later. In that instance, the defense says, listen, we need an incentive to try and settle this case now. Otherwise, why should we go ahead and settle? Let's just wait for trial and see what happens at that point. So that is a negotiation strategy that the defense might use. And I told my client that. So what happened here? What happened here is that the defense was unable to go ahead and make a substantial offer. And so we continued on through the discovery process until the point that we were now ready for trial. As we were getting closer to trial, the defense reached out and said, look, is there anything we can do to try and negotiate this point so that we could try and possibly resolve this without the need to go to trial? And we began to engage in settlement discussions again. The defense ultimately came back with an offer of $500,000. Now, I had to go back and tell my client about this offer. And that prompted me to go ahead and have this discussion, which I've already discussed with you at the beginning of this video. She was outraged. Because why? Because I told her a year earlier that her case was worth $1 million. So what changed? I'll tell you what changed. My conversations with her treating doctors revealed that this woman has done a remarkable job of recuperating, that they don't believe that her injuries are going to be permanent or disabling. They think she will not need any additional care and treatment. And because of that, now I had to change my analysis of this particular case. How would the defense have known about that? And the defense would understand that her injuries were no longer disabling or permanent? I'll tell you how. Because as we get closer to trial, the defense asks us for permission slips that will allow them not just to get copies of updated medical records, but also the opportunity to try and speak to her treating doctors. And we are required to give them those permission slips. So by sending off those permission slips and talking with a few of her treating doctors, the defense was able to determine exactly what I had already learned a few months earlier. And because of that, now they clearly understood what the true value of her injuries were. And that's why they ultimately came back and said, listen, we believe that her injuries are really worth only $500,000. You may have demanded much more money to settle this case, but guess what? We don't believe that her injuries have that type of value. And they actually challenged me. They said, look, if you can show me her medical doctors, show me her records that establish that she has ongoing permanent medical needs and will require surgery, then we can have a further discussion. But based upon her recent medical records, her updated records, we don't feel that there's any basis to offer anything more than $500,000. So now I had to have that conversation with my client. And yes, she was upset. But importantly, and I give her credit for this, she totally understood at that point. When I gave her that opinion back then a year earlier, that all of her injuries were permanent, lifelong, and would never go away. Well, guess what? Now she understood that things had changed. And now, thank God for her, her injuries will not be as bad. And she'll be able to continue on with her daily activities. And she'll be able to return to work. And all that is great for her, but bad for any negotiation. So why do I share this quick information with you? I share it with you because it's eye-opening. And it's critically important to understand that even though I gave my client an analysis, an opinion about what the value of her case was at that time, it's very important to understand if there are changes that have occurred from the time of that initial discussion about trying to settle the case up until the time that you actually engage in meaningful discussions. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.